Episode 188 of the Interpretation Station is Call to Order. Welcome, ladies and gentlemen. How is everybody doing? Today is the 15th of August, 2023. I've got 6 more days of holiday left. Going back to work, it's starting to become a reality. Never mind. Today's episode is especially for you guys with French in your combination. It's quite a complex text I've found for you. There's a lot of legalese in it, with a lot of very technical expressions. Now, why have I chosen the text that I have done for today? Well, with this kind of text, right, you could be the most naturally gifted interpreter in the world, right? You may be able to sit down just any old meeting and you can just breeze through it, wing it. You might just have a natural gift for interpreting. However, there are just certain meetings, certain situations that you're going to run into where if you don't have a comprehensive sort of knowledge of technical expressions, for example, here, I don't know, that might be in terms of medicine or law. Here we're talking about law, obviously. If you don't have that sound knowledge, rudimentary knowledge of the main technical expressions, then you're going to come a cropper, as we say. So this text we've got for you today, it's all about lawsuits that have been brought with regards to, in this case, France failing to follow up fully on some of its climate change commitments. And as I said, there's lots of very useful sort of boilerplate French legalese here that can be very difficult to handle going into English. So as I say, even the most naturally gifted gifted interpreter, if he comes and just drops into a meeting like this, a statement like this, and you don't know those technical expressions, then you are going to run into trouble. I've been thinking for a couple of days of a good analogy to find to best reflect the situation, right? Bit of a strained analogy I came up with, right? So the sport of show jumping. I'm sure you're all very familiar with show jumping. Yes, big sport in the UK. You might be the best natural show jumper in the world. You might be great at jumping over those fences when they go out in the countryside, and then when they come into the stadium, jumping all over those. You might do that absolutely brilliantly, but you are never going to be the Olympic champion unless you are properly prepared. You have that third discipline in show jumping, right? It's the one that nobody ever watches because it's so technical that no one other than really horsey people understand what's actually going on. It's called dressage. I'm wondering, have I used this analogy in a previous episode sometime? I might have done, I don't know. Anyway, that dressage is the first discipline, I think. And it's the idea, the aim of that dressage is to show what great control the rider has of the horse, that it can just make it do some very minute movements that to the layman obviously we wouldn't understand, but to experts, to professionals, they can see whether the rider is in full control of his steed or not. And so these kinds of using that rather strained analogy, this text is a bit like that dressage, okay? It's really showing you, it's going to show whether you can, you might be great, just like in show jumping, great at jumping over the fence and all that, but can you do the bread and butter stuff, the real basics, the real technical stuff? And hopefully this, going through this text, will improve our knowledge of some of that technical stuff, that technical French vocabulary, and seeing the best way of putting it into nice-sounding English. So without any further ado, let's bring the text up and go through it. Okay, so here we go. Here we have the text. I'll have to look through and see if I can find the original. I got a feeling it was sort of earlier this year sometime. Even if I can't find the original, I'll get my daughter to read out nice sounding French so that you can practice it. But it's really important. This is more what we're focusing on with this episode is more just looking at this very specific technical vocab. So even if I can't find the original for you to practice it, I would just have your notebook out or wherever it is that you note your note your vocabulary, and get ready just to note down some of the solutions that we come up with. Again, the solutions I give, I'm not going to say that they are set in stone. These are just my ideas, having done this text earlier in the year and having gone through it in quite some detail in the last couple of days. I've been looking up some of the various words and expressions used, trying to find good English equivalents. We as interpreters, we don't have to be 100% perfect. We do want to find solutions that give a fairly good reflection of what the original is, although there's not always going to be a 100% like-for-like solutions when you're going from, I guess, French law into English, because some of the mechanisms that exist in French law, I suppose, are sort of unique to France. So sometimes we have to sort of wing it a little bit. But if we are going to wing it, let's make sure that we know as best we can. Let's try and stay as close to the meaning of the original as possible, okay? So here we go. Accès à la justice dans le contentieux du changement climatique. Okay, so first sentence here. Plusieurs types de contentieux climatique. Okay, several types of, contentieux, right away, this word contentieux. It's not usually we talk about contentieux, it tends to be disputes. However, in this scenario, when it's talking about law, I think we talk about less about disputes as you would. And the charter, we talk about résolution de contentieux, disputes that's usually between countries. Now, what about in court? And you'll see I've made notes here, and so I was thinking to myself, what we like to maybe say in English. So several types of climate actions, maybe, or lawsuits was another idea that came to me. Have appeared in France in recent years. I guess you could say disputes if you want to play really safe, but to me, I think we talk about when the cases go to court. Often we talk about different kinds of actions or suits. Claims, again, is maybe another one you could go for. So what are those three kinds of actions? Actions against les entreprises, I think you could just say against companies or against business. Actions against, I'm just skipping, if I'm interpreting this, I'm just sort of dropping the diriger. If I didn't have the text, this would be really difficult to do without the text, okay? Actions against, I looked this up in the dictionary. And in Lingui, I think I just found specific administrative authorizations, or even particular administrative authorizations. There's nothing really fancy you can do with that. Or actions against climate policy of states. Okay. Now, in this third category, deux affaires, so two cases, have been pioneers. Also when we talk about cases, lawsuits and things, we have to talk about landmark cases. So an English speaker might say in this third category, two landmark cases have been, okay, then go on, contestation de l'action. But if you're right behind the speaker, so two cases have been pioneering, two cases have been pioneers. Dans la contestation de l'action. So again, here I thought the best was in challenging government action when it comes to combating dérèglement climatique. Okay, be careful. You might not. This is an expression that the French use a lot to just say climate change, okay? You don't need to do anything fancy with this. You don't need to talk about climate disruption. So, dérèglement climatique, you can just say climate change, okay? Okay, so the Commune de Grande-Sainte case, and so I think I called this just the Notre Affaire à tous case. Sometimes you just stay with because it's, you can try and put it into English, everybody's case. I think I thought about it and I just decided I'm just going to call the case in its original the Notre Affaire à tous case. Se distinguent par leur nature. Stand out. That's all you need to do for se distinguent par leur nature. Just keep it simple. Stand out. To best understand this difference, il convient de revenir brièvement. Okay, we need to return briefly to the two major categories de recours en contentieux administratif français. Okay, so here, so actually my booth mate was initially preparing it, so some of these are his notes. I quite like this judicial review for recours en contentieux administratif français. Now, I think he was also going to add in recours en contentieux. He was going to say application, the two major categories of application for judicial or for French judicial review. To be honest, I think you could just drop application, just the recours, and just say we need to look at the two major categories of judicial review in France. I think that's very good. Judicial for recours review. Les recours pour excès de pouvoir, so review for abuse of authority. That's an important concept, obviously. You definitely want to have that pretty much word for word. Abuse of authority on the one hand. Now, this is interesting. Qui tend à l'annulation d'une décision administrative. Now, okay, we have the word annulment, which aims at the annulment of an administrative decision. But I think in English, we tend to speak about overturning things or quashing things. So maybe we would say a review for abuse of authority on the one hand, which seeks to overturn an administrative decision or seeks to quash an administrative decision. So I would turn that noun into a verb in English. Overturn and quash, they're very good words. Now, this is the case with the Grand Saint Contentieux action. Or again, case, you could just, I think, an English speaker might just say the case. Oh, so that sounds a bit strange. This is the case with the Grand Saint case. The Grand Saint suit. Well, the first claim for abuse of authority within a climate action that has faced the high French administrative jurisdiction. Again, I think I looked that up, and that was really, just the high French administrative jurisdiction. Was it supreme? Maybe in Linguist they give supreme. Yeah, there was nothing very fancy really to do with this, just the high French administrative jurisdiction. The Council of State, le Conseil d'État, just called Council of State, qui était dirigé contre un refus de prendre des mesures utiles. Now, again, all these words taken individually, pretty straightforward. Okay, dirigé, directed. A refusal. But, in English it sounds, I don't know if you would say that in English, which was directed against a refusal to take useful measures. And then la demande d'annulation étant assortie d'une injonction. I could, if you were doing this on the fly with that text, I suppose you could be forgiven for saying, which was directed against a refusal to take useful measures, the request for annulment being accompanied by an injunction. Okay, you could say that, okay, but it doesn't, to me, sound very good. We don't direct for a start, we don't tend to direct a claim, recours, an action, whatever. We tend to bring it, okay? So, and we don't tend to bring a claim against another decision. We tend to bring it maybe following, which was brought following un refus de prendre des mesures utiles. I think, brought following a refusal to take useful measures. Again, in a court situation, in demande, a request, you could pass. But I think the motion for annulment. Again, do we really talk about annulment in a context of in a legalese context? I mean, again, we would be understood, but I think it would be nice to say the motion to overturn being accompanied by an injunction. Okay, so injunction, you can just use the cognate. But this is what I mean, okay? This kind of thing sets the men apart from the boys. It really shows how good you are or not, this kind of sentence. You know, the lazy interpreter who hadn't done his homework would probably just say, which was directed against refusal to take useful measures, the request for annulment being accompanied by an injunction. But the boss interpreter, right, the guy who's done his homework, would say something like, which was brought following a refusal to take useful measures, the motion to overturn being accompanied by an injunction. So again, it reminds me, English is a verbal language, and French is a more a nounal language. As one of my former colleagues, I remember saying many years ago, and it's a good thing just to remember that, because the French do like to express situations with nouns, whereas we English speakers tend to lean more towards verbs. So there you go. I think for the motion to overturn. You talk about what gets an annulment of marriage, we'd say in English, but when it comes to decisions in court, we want to overturn them. Okay. Les recours en responsabilité. So my colleague here put a liability claim, and I think that's the best solution. The liability claims, or recours indemnitaire d'autre part, compensatory claims on the other, which seek to obtain réparation, so compensation, remedy, redress. Is generally the word we want for réparation. But réparation d'un préjudice, I think this is damages. I think all this could be synthesized into one word in English, which seek to obtain damages en engageant la responsabilité de l'administration by finding the administration liable. Okay, this is, as I say, this is really technical stuff. So again, you could be forgiven for saying on the fly to obtain reparations for damages by engaging the liability of the administration. But I think if you've got the time to prepare this, it's good to think how in English you would say this in the smoothest way. I think we'd say something like which seeks to obtain damages by finding the administration liable. That is the case with the Notre Affaire à tous action brought by several environmental protection associations to former un recours. Okay, former un recours. What do we do with a claim? What do we do with whatever un recours indemnitaire? With a compensatory claim. So again, we bring it. In fact, I've given you three alternatives here. We lodge it, we bring it, we file it. These are three excellent synonyms for you to remember. Note those down in your vocab book, okay? To file a compensatory claim before the Paris Administrative Tribunal, the first instance jurisdiction, calling for a symbolic euro in reparations for moral damages and a euro in terms of environmental damages. And then also my colleague, un recours indemnitaire, a compensatory remedy, is that what he's put there? So yeah, but anyway, to bring a compensatory claim, I think a recours is still claim more, so maybe to lodge a compensatory claim before the Paris Administrative Tribunal, the first instance jurisdiction, calling for a symbolic euro in reparations or in damages for moral harm, and €1 for environmental damages. We will examine in detail these two cases. First of all, l'objet de ces contentieux. I think in English, the objet would become the subject of these contentieux, of these claims. So I'm going to, the contentieux is going to appear quite a lot throughout this text. I will probably use different solutions. I'll mix it up. Secondly, the question of, l'intérêt à agir. Now, this is a big issue in this meeting. L'intérêt à agir. And So I'm going by what they were saying in that meeting, and the expression they were using in that meeting was standing. Okay, this seems to be that was the buzzword in that meeting, I remember. Standing, not interest to act. Again, so just bear that in mind with French legalese, that is a expression you may run into. That's the best. That seemed to be what was the French speakers were using to reflect that notion during that meeting. Des requérants. Okay, I think the petitioners is a good word. The ones who brought the motion, right? Thirdly, the implementation of the powers of the judge. And finally, a perspective on the evolution of these claims. So the subject of climate claims. In the first case, the commune of Grand-Sainte called on the Council of State d'annuler le refus du gouvernement. So again, we can say to overturn. Again, you could, like my colleague did here, I suppose you could use the cognate, but I was saying earlier on to overturn, to quash the refusal by the government to take additional measures to reach the goal of reducing greenhouse gas emissions by 40% by 2030, à issue de l'accord de Paris, as per the Paris Accords, an international legally binding treaty on climate change, concluded, reached in the context of the Conference of Parties to the UN Framework Convention on Climate Change. Maybe you'd say, you could just say the UNFCCC COP, Conference of Parties. Acronym is the COP, okay? The UN Framework Convention on Climate Change is the UNFCCC. So again, feel free, I think, to use those acronyms when you have the chance. The petitioner does not challenge, ne conteste pas, because it doesn't contest. The definition also doesn't contest the definition of national greenhouse gas reduction goals to limit climate or global warming to a level below 2 degrees. But le caractère suffisant, the sufficient nature, and the funny thing is in English, we would talk about the insufficient nature, because obviously they are complaining about what hasn't been done. So an English speaker would say they're challenging the insufficient nature of the measures taken to reach this. What was asked of the judge was not to renforcement des cibles. It was not what was asked of the judge was not to toughen the targets, but to bolster the instruments, the tools, I guess you could say. In Notre Affaire à tous, 4 environmental protection associations introduced or brought 4 claims before the Paris Administrative Tribunal in order to faire reconnaître, I think you just say, recognize la carence de l'État. So my colleague here, the deficiency of the French state, the failure of the French state in combating climate change, the shortcomings of the French state in combating climate change. D'obtenir sa condamnation. Now, usually, condamnation, finding guilty, finding someone guilty, right? But in a civil case, I think when you're bringing something against the government, it's not really, I don't think in English we talk about really finding them guilty. I think it's more we'd find them liable à réparer non seulement leur préjudice moral, mais également leur préjudice écologique. So find them liable for remedy, not only for moral damages, but also environmental damages as a result of exceeding the first carbon budget. And then I've just done a bit of research here. Yes, dépassement du budget, an overrun. It reminds me of the good old days back in New York doing the ACABQ. Yeah, if you ever work in the UN in New York, you're going to have the ACABQ, and they often talk about these, what are called cost overruns, budget overruns. I think that might be a very good word for that when you're talking about a budget. So as a result of overruns from the first carbon budget. overspend, they talk about sometimes, but I think an overrun is good here. And to put an end to the failure of the state in meeting its obligations. On we go. In this case, the associations call for a remedy to a past failure, while in the Grand Sainte case, the claim concerns the refusal to take measures to achieve a future goal. Intérêt à agir direct requérant. Here we go again. Standing. All right. Again, if I'm wrong, if you guys have got more experience in this kind of thing, maybe you specialize in this kind of law in your interpreting in your job. So maybe you have maybe you know the right answers, as it were. So if you have that added knowledge, please do share it with us in the comments. I love getting comments. Okay. So in French administrative cases, in French administrative claims, on estime que it is thought that to justifier d'un intérêt donnant qualité pour intenter un recours pour excès de pouvoir. Oh, dear me. I was thinking here, so to establish, to substantiate intérêt, again, standing, to establish standing in bringing a claim for abuse of authority. That's how I would do it, okay? To establish, for justifier, to establish, to justify, to substantiate an intérêt, a standing, donnant qualité. I think you can sort of just skip that. I would say to establish standing, to lodge a claim for abuse of authority. Le justiciable. So I went here with I've scribbled in the litigant. Now I think you could also perhaps say the plaintiff. So I must admit that here I'm not 100% certain if the justiciable is the person bringing the case or the sort of defendant, as it were. So when you go to Lingui, it gives you like the litigant. But this seems to be referring, or rather, yeah. It seems to me that the person it's referring to is the person bringing the case, which would be the litigant or the plaintiff. However, justiciable somehow sounds to me also is the person who the case is being brought against, which of course would be the defendant. So I'm not 100% certain if it's which side it's talking about. I would have thought it would be the person bringing the claim, the plaintiff. I don't usually like, by the way, American English, but I do like the word plaintiff, actually. I think that works quite well. But is it the plaintiff or is it the defendant? The defendant, who would, of course, be the French state. Anyway, the litigant, perhaps litigant is a sort of neutral word, must establish that the act in attaqué, in question, we'll say, the attacked act, I mean, that just sounds stupid in English, affects their interests in sufficiently special, certain, and direct conditions. L'appréciation de l'intérêt spécial, recognition of standing, traditionally seeks to avoid a situation where recourse to abuse of authority would be transformed into a action populaire. This is very important, a class action. Okay, so I looked that up. An action populaire. Remember that, a class action. So yeah, the recognition of standings traditionally seeks to avoid a situation where recourse in abuse of authority would transform itself into class action. La requête devant le Conseil d'État, the motion, the application, the claim before the Council of State, was submitted, okay, by the Commune of Grand Sainte and by an individual in particular, Monsieur Carême, who was mayor at the time. The Council of State admis l'intérêt, so upheld, I think is recognized or upheld, I think that's a good word in English, the standing of the commune in view of its level of exposure to risks découlant du, stemming from, emanating from, arising from the phenomenon of climate change and their direct and certain impact on the situation and interests that they were responsible for, or just the situation and the interests inherent thereto. The judge, en effet, let's just delete en effet, noted that owing to, due to its immediate proximity to the coastline and the physical characteristics of its territory, it was exposed in the medium term to a heightened risque accru et élevé. I mean, they're just a sort of tautology, isn't it? Same meaning. Okay, a heightened risk of flooding, of a worsening of episodes of forte sécheresse, high droughts, impact avec pour incidence, impacting in terms not only of lowering and degrading ressources en eau douce, freshwater resources, but also causing significant damage sur les espaces bâtis, so to the built environment. I can look that up for espace bâti. I did initially think built space, but maybe built environment is best, in view of the geological characteristics of the soil. This is a tricky sentence, right? So again, maybe it was exposed in the midterm to increased risks of flooding and to worsening episodes of droughts, serious droughts maybe serious droughts, worsening of episodes of serious droughts, avec pour incidence, with an impact not just in terms of reducing or decreasing and degrading freshwater resources, but also causing significant damage to the built environment in view of the soil, the geological characteristics of the soil. Si ces conséquences concrètes du changement climatique ne sont susceptibles, okay, again, so this is one of those si expressions that goes while, okay? I mean, if you have the luxury of being able to see the text, obviously you can see that again. If you don't have the text, the way to play safe with C is just to drop it and turn it into two sentences. But anyway, because we have the text, we're going to say, while the full effects of climate change are unlikely de déployer tous leurs effets, I guess we could say here, so while the full effects of climate change are unlikely to be felt on the territory of the commune until 2030 or 2040, leur caractère inéluctable. This is a word I've run into a couple of times recently. I was thinking what the best, I mean, you could say inevitable, I guess. Their inevitable nature. Their inexorable, though, is a really good alternative. Very high register. Their inexorable nature, there's just no getting away from them, right? In the absence of effective measures taken swiftly to prevent their causes, and in view of the horizon for action of public policy in the field, is such as to justify the need to act immediately to that end. Okay, now, so these are tough sentences, long sentences. So what would we do if we didn't know, if we didn't have the text? Maybe we'd drop, so, with C, you just leave it. You say the full effects. That's what I've written for conséquences concrètes. The full effects of climate change are unlikely to be felt in the territory of the commune until 2030 or 2040. However, their inexorable nature, in the absence of effective measures taken swiftly to prevent or to tackle the causes, and in view of the horizon for action of public policy in the field, is such as to justify the need to act urgently to that end. L'autre requérant est un particulier. The other petitioner is an individual, Monsieur Carême, acting on his own behalf and in his capacity as mayor of the commune of Grande-Sainte. The Council of State, however, considéré. So what do courts usually do? They don't tend to consider, they tend to find. I think that's a good verb to have when you're talking about court decisions. To find. Okay, the Council of State, however, found that this capacity was not sufficient to give him standing, again, intérêt pour agir. Not even the fact that his current residence est implanté is situated in a zone likely to be flooded annually in 2040. À titre informatif, I mean, that's really, it was an FYI for your information. For background purposes, Monsieur Carême then lodged an appeal before the European Court of Human Rights, the ECHR, if you want to give it its acronym, alléguant une violation, maybe say invoking a violation, alleging a violation, invoking a violation of Articles 2 and 8 of the Convention, au motif, on the grounds that the national judge méconnu ses droits à la vie. Yeah, I think maybe the best thing to go for is it had ignored, had overlooked. Where are we? On the grounds that the national judge had ignored his right to life and to private and family life by rejecting his claim, seeking to ensure that France met or respected its maximum emission limit caps. I put caps. There we go. I think that's my writing there. It's limits. Okay. I guess I maybe thought about it a bit at the time. So yeah, I think countries have caps, right? A limit that they're that they can use. There's a good sort of synonym, perhaps, for the caps established under national law. Une audience, a hearing, will take place in the European Court on the 29th of March. So this must have been early on this year. Moreover, several interventions, a number of interventions have been submitted in support of this motion. The Council of State noted that the city of Paris and city of Grenoble had established standing to intervene when they were identified as having an indicator of exposure to climate risks described as very high, qualifié de très tôt, described as, classed as very high. The phenomenon of climate change will lead to a significant increase in pics de chaleur, so heat waves. This was heat spikes. Can we talk about heat spikes, I wonder? I think heat waves is the safer solution. Noted, recorded on its territory, both in terms of their intensity as well as duration, as well as a significant increase in winter rainfall, renforçant le risque de crue, heightening the risk of rising water levels and subsequent flooding. So yeah, I thought, because there's two things here, crue d'ampleur and inondation subséquent. Okay, the inondation is flooding. So, crue is rising water levels, sea levels. Yeah, water levels. So that's why. So I've said sometimes crue can just be a flood as well. I mean, again, if you're in a hurry, I guess you could say just heightening the risk of flooding. They're pretty similar, those two notions, crue d'ampleur, inondation, seem to be pretty similar ideas. But if you want to draw a distinction, that's why I said rising water levels. Finally, 4 environmental protection associations were considered to have standing to intervene since they had since their goal, elles ont notamment pour objet, was to combat atteinte anthropique à l'environnement, anthropogenic damage to the environment, or man-made damage to the environment. And then, dont l'une des manifestations, I would probably just put a full stop here and just end the sentence, okay? One of its manifestations lies in the contribution of the phenomenon, in its contribution to the phenomenon of climate change. It was these same associations who introduit devant le tribunal administratif, who introduced before the administrative tribunal in Paris several weeks later, le recours en responsabilité. So as we said before, a liability claim against the state in notre affaire à tous. Their standing in this instance raised no question marks. Mise en œuvre des pouvoirs du juge, so implementation of powers of the judge, the grand sainte. Through a first arrêt, so I tend to play safe here with this word, a ruling. Okay, when arrêt is used in the context of courts, through a first ruling of 19th December 2020, the judge recalled that the goal of reducing greenhouse gas emissions by 40% between 1990 and 2030, as per the Energy Code, which specifically mentions the UNFCCC, as well as the Paris Accords. Its goal is to ensure the effective implementation of the principles established under the Convention and the Accords. To that end, to effectively reach this reduction goal, a national greenhouse gas emissions ceiling, I think we can just say ceiling, okay, called a carbon budget, was set for the period 2015 to 2018, and then for each consecutive period of 5 years. So again, it's pretty dense stuff, but that paragraph's fairly doable. The Council of State noted, however, that France had substantially exceeded its first carbon budget. The High Council on Climate stressed political insuffisance, shortcomings in achieving the goal set in a report of July 2020. The national greenhouse gas reduction goal at the end of the period 2019-23, corresponding to the second carbon budget, a été revu à la baisse. Now, okay, what's the nicest way of saying something like this in English? Because this is an expression you hear frequently, okay? And I thought about it, has been adjusted down. We adjust estimates up, adjust down. I think that's the nicest way of doing that. Just as when they often talk in French, don't they? Tendance à la baisse, tendance à la hausse, when they talk about shares, right? I think in English we talk about trending up and trending down, okay? I'm quite pleased with those solutions. But anyway, so here, revu à la baisse, adjusted down. À l'occasion, during the review of the National Low Carbon Strategy in 2020. Now, this is tricky. Opérant ainsi un décalage de la trajectoire de réduction des émissions, leading to thus slowing the pace of emissions reductions, and postponing a big push until after 2020. Okay, so I was again sitting down trying to think about the best way of expressing some of this stuff. And décalage de la trajectoire. I mean, the idea is that things are behind schedule. So keep that expression in English in your head. Okay, something's behind schedule. Décalage de la trajectoire. Arrears. It's that whole notion of things being behind, running late. So again, I thought the best way of doing this was, yes, slow, because I had the text to prepare. I said, slowing the pace of emissions reductions, which lead to postponing l'essentiel de l'effort. You have a big push until after 2020. Now, behind schedule, now if you're just hearing this, you don't have the text. And décalage de trajectoire, the idea is that things are late. It's just good to have that idea of being behind schedule, because you can sort of try and reconstruct it, the idea a bit in English. You can sort of paraphrase it, but you need to have that idea of something being behind schedule. So you might, for example, say, during a review of the National Low Carbon Strategy in 2020, meaning that emissions reductions were behind schedule and that the big push had to be postponed till after 2020. Something along those lines, okay? Now, the most recent scientific data, particularly reports published by the this is very important, Groupe d'experts intergouvernemental sur l'évolution du climat, the Intergovernmental Panel on Climate Change, that's their full name, okay? The IPCC. That you can use, I think you can use that acronym straight away. But yeah, évolution du climat, that can also be climate change. All these things, dérèglement du climat, évolution du climat, changement climat, climate change. And it's called the GIEC, okay? That's an acronym I've heard them use, okay, for the IPCC, GIEC. Highlighting aggravated climate risks in the event of continued temperature rise. Okay, so I paraphrase this slightly in English when I was preparing it. In that context, the Council of State found, again, a considéré, that it could not statuer a rule or take action on the motion to overturn the refusal to take any useful measures permettant d'infléchir la courbe des. So all this, I guess, synthesized into one word, to curtail, okay? To curtail greenhouse gas emissions in the absence of any elements to establish, permettant, I'm just sort of dropping that, to establish the compatibility of the refusal as opposed to the schedule for greenhouse gas emission reductions to achieve the goal, and as a result, called on the government to justify within 3 months that the trajectoire, again, the schedule for greenhouse gas reductions for 2030, 40% down on 1990, 37% down compared to 2005, could be met without additional measures. Good God, that's a whole one sentence. I expect this thing usually from the Spanish, okay? I know the French like the flowery language, but God, that's a really long sentence, isn't it? So yeah, infléchir la courbe, curtail, I think that works nicely there. And then often permettant, I think, sometimes can be a redundant word. You can just say that it couldn't rule on demand to overturn the refusal to take any useful measure to curtail greenhouse gas emissions in the absence of elements establishing the compatibility of the refusal with the schedule for... Yeah, so I think you can often... Permettant is a word that when you're under pressure that you can drop. Notre affaire à tous. Through a ruling of the 3rd of February 2021, the Paris Administrative Tribunal found, a considéré, that the state should offset environmental damages caused by failure to meet the goals set by France in terms of reducing greenhouse gas emissions, more specifically, the overrun in the first carbon budget of 61 CO2 megatons. Equivalent. What's the measurement exactly? It's important to know exactly how they express that measurement. Yeah, they talk about metric tons of CO2 equivalent. So yeah, we would say 61 megatons of CO2 equivalents. Il a également ordonné un supplément d'instruction. It also called for... Also, does the court decree things? The court also decreed a further investigation before ruling on the assessment and the modalities for specific compensation for damages, or for specific damages, the modalities of... It also decreed a further investigation, or it also called for a further investigation before ruling on the assessment and modalities of the specific modalities for payment of damages, for example. Then, through its ruling of 14th October 2021, the tribunal noted that a drop in greenhouse gas emissions of a level of 47 megatons of CO2 equivalents between 2019 and 2020 permettait de considérer, so again, just indicated that the environmental damage had partially been réparé en nature, had been offset, but that it remained at a level of 15 megatons of CO2 equivalents. As a result, the tribunal ruled that, on the one hand, there was a need to ordonner au gouvernement, instruct the government to take all useful sectorial measures to remedy damages at a level of the unmet share of greenhouse gas emissions under the first carbon budget. Again, this is very tricky. Okay, repeler préjudice. Okay, so again, a remedy the damages at a level de la part non compensée. So again, I wrote that in the unmet share. I remember this took me quite a while to prepare this text. These legal texts these French legal texts can be absolute hell. I would also point, if you really want to get stuck into a legal text, I would also suggest you go and visit a previous episode I did taken from the ILC a couple of months ago, the International Law Committee, where it was an absolute killer by one of the members there, about 7 or how many pages was it of absolutely killer French legalese. Give it a try. Go. I'm going to put the link up there so you can visit it. Where are we? Also, offsetting damages. Payment of damages will be made effective as of 31st December 2022 at the latest. Enseignement, lessons learned, and prospects d'évolution going forward. So, les contentieux climatiques, so climate actions have appeared in France through these two affaires emblématiques, like I said, through these two landmark cases, facilitated through broad access to a judge. The number of claims of this kind remains limited for now, since these two cases were of a national magnitude, national scope. However, the Notre Affaire à tous case n'est pas terminé, is not over. Pending, dans l'attente de, pending in just one word, pending conclusive data or conclusive information. I was quite pleased with that for définitive, better than definitive. So conclusive data on measures taken to remedy damages linked to the overrun in greenhouse gas emissions under the first carbon budget. Le respect de l'injonction. So observing the injunction, often observe. Respect is quite a Frenchicism, you know. You can respect things, but I think we like to observe things in English. Observing the injunction in the Grand Sainte case is also under review. The Council of State is due to assess whether the measures adopted since July 2021 to effectively curtail greenhouse gas emissions produced, you can just use the cognate, generated on national territory, to ensure their compatibility or consistency with the greenhouse gas reduction goals by ahead of 2030. However, we should point out that the recent compensatory claim through which the City of Paris invokes the failure of the state when it comes to greenhouse gas emissions reductions and to climate change adaptation, and requests or calls for reparations for economic damages and for damages in terms of, now what about this, atteinte à la réputation et à l'image de marque de la ville. So again, I gave this one a lot of thought, okay, for bringing the city's name into disrepute. Ooh, baby, I really like that. So just to give you that full sentence again, it's all one long sentence. We should, however, note a recent compensatory claim whereby the City of Paris invokes the failure of the state in terms of reducing greenhouse gas emissions and climate change, and calls for compensation for economic damages and damages in terms of bringing the city's name into disrepute that it suffered. I think I just left out qu'elle estime avoir subi. This new case laisse augurer, I think we can just say, this new case suggests that the struggle against climate change is a new source or a new grounds for claims qui a peu de chances de se tarir. Now, I seem to remember coming up with a good solution for this, qui a peu de chances de se tarir. I mean, I guess in English, which are unlikely to go away. So I don't know, that's maybe the best way of saying in English. This new case suggests that the struggle against climate change is a new grounds for claims which are only going to increase, okay, whose number will only increase, something along those lines. If the better solutions comes to mind in the next couple of days while I'm producing the episode, I will be sure to put it up on the screen for you. So there you go. That's again, a legalese roller coaster for you there, that one. So as I say, the focus here is not so much on trying to do this in, simultaneous. The focus in this episode really was me just trying to iron out some of these key phrases and expressions for you so that, in future when you run into them, maybe you'll suddenly remember episode 188 of the Interpretation Station, and some of that knowledge might sort of come back to you. And that's really the idea. So if you have learned some new stuff, please do tell me about it. Do comment. And again, if you have some better ideas on any of the expressions and the vocabulary that we've run into today, please do comment, like, subscribe, the usual. Share it with your friends. You know what to do. And really, that's pretty much all for today's episode. It's been a pleasure as ever. And it means that all I have to say is that episode 188 of the Interpretation Station stands adjourned.